action to enforce this code, then if the town wins, it gets its legal fees and other costs. So if you've got to hire a lawyer to enforce this, you've got to hire an engineer to enforce this. You don't want to be in a position where the good news is you won, you got a $350 fine from this person who thumbed his nose at you, and the bad news is you spent $3,500 in, yes?
Conversely, if it's, I'm not talking about just the gas here. Suppose there was a challenge on the transient rentals, and the person disagreed with it, and it ended up that the town said, we're going to enforce this and takes you to court. If the transient rental wins, does the town then have to pay their fees or any other challenge, or is it just in reverse the town gets reimbursed?
In the private world, it would be typical that the winner got it. So you say, in the event that either party brings an action to enforce or interpret. The way this was drafted, only the town gets it. But if you want, so no. So the transient rental or anybody else person, if they won, would be, So there's two possible fixes for that. One is to make darn certain that these people who you elect aren't going to bring actions like that unless they're pretty sure you're in somebody's in violation. But otherwise, then I think I interpret that question to say to Chris to take to the town board or to the committee. I hear that question to say either limit this just to the gas drilling provisions, or make it, it's called reciprocal or mutual, so that even if the town happens to be the one that loses, it pays its fees. And then they can talk about that and decide what they want to do. Is that fair to say that's your comment that you want to take away from that?
Well, I was just using that because that's something, but I'm also thinking it wasn't only a few years ago that there was a road lawsuit, and we hear that often, and conversely, with that, and that's what I was just wondering. So whether the town would be liable in reverse for any challenge, I just use that.
They won't be under this language.
Okay.
But the person who drafted this was representing the town. You certainly could write it that way, and that would be typical in a contract provision.
As a representative of the town as a supervisor, I'd be real hesitant to change.
Oh, I can understand not wanting to put it in.
Okay.
If I was going to do it, I would, when I wrote my lawsuit, I would ask for it, yes.
Yeah, we want to cover the town.
Yeah. No, I understand protecting the town.
Yes.
In the debt collection and contract field where I've practiced.
You speak up just a little. I went to too many concerts when I was young. Although I still go to them.
In the debt collection and contract law in which I've practiced, case law is that judges have found it unconscionable for the writer of the contract to put in that they're going to get legal fees and not allow the other side that same right. So therefore, if attorney fees are in the contract, the winner gets. And they also recommend that you say reasonable attorney fees so that the court has some oversight and can determine what's reasonable and not hit someone with attorney fees of $300 or $400 an hour or things that are totally unreasonable for this area and not on wasted hours too.
Well, first of all, on point 2, did everybody hear that? So first of all, on point 2, it's no problem to put reasonable in. And I've written reasonable so many times that I had to slap my hand and not put it in here. So you're right, that's virtually always the case. And if it's not in the first draft, somebody puts it in a second. So we have no problem putting reasonable in. As to your first point, I hear what you're saying, but that's a special area of the law, and it's a special area of the law that involves special types of contracts called adhesion contracts, which I'm sure you know about as much as I do. And so it's true that anything that's in an adhesion contract is basically a consumer type situation where it's a take it or leave it. If you want to buy this refrigerator from Sears, you're not able to negotiate that contract. And so, which includes the part that might say you get attorney's fees, they get attorney's fees, or it goes to arbitration, or whatever it is. And so you're absolutely correct that they will either throw it out or make it mutual. My own view is that's not the case here, that line of reasoning, which I understand and agree that it's accurate in that area, I do not agree that it applies in the municipal law area.